to actually visit casinos. And we do that both here in the state of Pennsylvania and beyond. And I'll talk about that a little bit later. To break down the courses with a little bit more detail, the introduction course, as I mentioned, compares and contrasts repeater market casinos with integrated resorts, like you might see on the Las Vegas Strip. We give them an overview of the games that generate the most revenue, and we give them an idea of the different jobs that are available in both integrated resorts and repeater market casinos. In my operations management course, we use primarily case studies. So we, for example, let the students read problems that general managers would be considering when operating casinos, such as should they run their own food and beverage operations or should they outsource that? We talk about the different types of promotional programs that casinos might be considering. In the casino marketing class, we dive deeper into that and we discuss database marketing techniques, how we measure players by their theoretical value. We contrast, match play offers from discounting offers, from dead ship offers, and let the students understand the math that the casinos use when they consider these different approaches. Lastly, but certainly not the least important, is we have an issues in gaming course where we talk about things like problem gambling. We discuss whether smoking is something that casinos still need or not. In other words, we try to tackle sort of all the issues that lie beyond just sort of the revenue side of the equation. We also have a casino management group, and the idea there is that this group really spearheads our trips, our outreach efforts. The students are involved in fundraising. They try to connect via this club to alums that we have both around the state of Pennsylvania and beyond. And also it gives them the opportunity to put some leadership experience on their resumes for when they finish. And really the feedback that we're getting from the companies is that they really are selecting students that are able to show that kind of leadership experience. Some examples of what we do in terms of outreach. Every year now we've developed a great relationship. It started with Bob DeSalvio at Sands Bethlehem and now has moved to Mark Giuliano. We take the students to visit Sands Bethlehem every year. Now they have actually provided us with 3 internships every year. So the students are able to gain something that's very rare for undergrads. They gain real operational experience at a casino, which really helps separate them when they're looking for jobs after they graduate. We have a good relationship with Rivers as well. We spent time bringing students down to the Hollywood Casino at Penn National Raceway. Every year we usually take 2 groups, one in the fall and one in the spring, to Las Vegas. The fall trip usually centers around the G2E conference out there. The students through the American Gaming Association are given full passes to all the educational events that occur during G2E, and they get to experience the show and see all the fantastic new machines and technology. We probably every other year we take a group to Atlantic City. And 2 years ago, and again this next spring in 2017, we'll be bringing a group of approximately 10 students to Macau to see what is going on over there in that part of the world. I just wanted to give you an idea of how the program works for some of our students. A couple examples that I just wanted to talk about was, for example, Greg Butto. I came to Penn State in 2012. And one of the first students that I met was Greg, and he came to me and he said he wanted to get into the casino industry. And really through Bob DeSalvio at Sands Bethlehem, we were able to secure him an internship at Sands Bethlehem. He was a pit clerk that summer, and while being a pit clerk at night, he went to dealing school. And then he was able to use that for the following year, and he got a job dealing blackjack at the Rio in Las Vegas. After he graduated in 2015, he was hired as a dealer at Wynn Las Vegas. and he spent about a year doing that. Now, he was recently hired by MGM Resorts in National Harbor as a table games floor supervisor, so he'll be coming back to the East Coast, which has always been his goal, and eventually he would like to come back actually to Pennsylvania. But that opportunity he had in operations as a sophomore was extremely valuable and really separated him from a lot of the other students that are graduating from an undergraduate program. Cassie Miller, she grew up in Pennsylvania, went through the hospitality program, and came to me actually as a junior, and we've helped find her an internship at the Cosmopolitan in Las Vegas. She then used that experience to get a job at MGM through their management training program, and she took a job in slot marketing. She's already had 2 promotions, and she's now been named manager of slot marketing for the Bellagio Resort in Las Vegas. Lastly, I wanted to mention Nick Shellman. He was a student that also came to me in 2012. We helped get him an internship at the Hollywood here in Pennsylvania. He has his fiance was going through Penn State in the educational program, and she was going to take a job working in Harrisburg here. And so Nick wanted to stay in PA from the beginning. So he took an internship in food and beverage at the Hollywood, then used that experience and the connections he built there to get a slot technician position, which then led to a supervisor position, and now in 2016 he's been named slot tech assistant manager at the Hollywood. We really think, to sum this up to some degree, that this casino lab will enhance our program. We're not going to teach students how to service slot machines per se. We're not going to actually teach students how to deal. But getting that hands-on experience is going to make a really big difference to our program, and I think make it come alive. When I try to teach games like Baccarat or Craps now in front of the classroom, I do it via a video screen, and it's just not that compelling. And the ability to put students on games, to let them touch, to feel it, to get a feel for what it means to be a dealer or what it means to be operations, I think will really help our program come alive.
And in summary, I would just like to add, that is in keeping with the tradition at Penn State, engagement with executives and leaders in the industry through our trips and our outreach, but also experiential learning, hands-on learning is part of the DNA of Penn State. And since 1937, it has been part of the School of Hospitality Management. We welcome you all to come and either dine in our student-run restaurant or perhaps we hope in the future visit our lab.
Thank you. Any questions from Enforcement Council?
Glenn Stewart for the Office of Enforcement Council. We have no questions and no presentation, and we have no objection to what Penn State's asking for. We would just recommend that the board implement at their discretion the conditions that we recommended in our answer.
Okay. Any questions or comments from the board or ex officio members?
One quick question. Thank you, Mr. Chairman. The reason we have you here, and you are now the second university in Pennsylvania that will be operating a lab, is we are very concerned about security. And so I have no question. I want to take the opportunity to say to you that security of the machines, limiting student access to, when there are supervisors there, professors there, is of the utmost importance. I mean, I don't have to tell you that, once this becomes known in the university, there will be students to say, let's go have a few beers and sneak into the lab tonight and play some games. And those are the kinds of things that make us nervous. So again, just a cautionary note. I know you will put all the necessary bells and whistles in place, but that's the one thing that we have the most concern about. So your presentation was great. So glad to see you doing what you're doing. Thank you.
May I? Please.
Thank you, Mr. Chairman. Mike, during your presentation, you mentioned something that kind of caught my ear, that has been an issue, I guess, As we go around speaking throughout the Commonwealth, something that always comes up is smoking in casinos. And you mentioned that. Bearing in mind it's part of the 2008 Clean Indoor Air Act, and we can't change it. What are your feelings on smoking in casinos?
Yeah, it's a complicated issue. I mean, there's no question that evidence suggests that smoking is helpful in terms of casino revenues. We see that over and over. You see that here in the state. If you compare the side of the casino in our casinos here in Pennsylvania, if you compare the side that you can smoke in to the side that you can't smoke in, there's no doubt that variable has a very positive effect on coin in. If you want my personal thoughts on it, I personally think the casinos would be wiser the quicker that they eliminate this, the better for everyone. Because I think when you really think about the long-term implications, I don't think that the courts are going to be any easier on industries that sort of maintain the smoking in terms of judgments. I mean, I probably shouldn't be speaking to the legal side of this, but that's my opinion, and I think that's where we're headed anyway, towards eliminating smoking. So the quicker that we do it, maybe the better for everyone. But I understand. I'm very well aware that that's going to have a negative impact on the taxes that the state collects and the revenues that the casinos generate short term. I mean, we've seen that now in Macau as well. So I don't know if I'm answering your question or not.
Macau is smoke-free?
Yeah, absolutely. Amazingly, the Chinese decided that on everything, in some of their high-end junket rooms, they're still allowing some smoking. They're not really supposed to, but they are. But on the mass market floor, there's no smoking anymore.
Thank you.
Just want to make sure, there's no presentation from...
We have no presentation, no, sir.
In that case, a vote on this will be taken up later today under the Office of Chief Counsel section of the agenda. Now we'll move on to the regular agenda.
Thank you.
Thank you.
Thank you for your time.
By way of announcements, the board held an executive session yesterday, November 15th, for the purpose of discussing personnel matters and to conduct quasi-judicial deliberations relating to matters that are going to be considered today. Next, we have consideration of a motion to approve the minutes and transcripts of the October 5th meeting. Do I have a motion?
Mr. Chairman, I move that the board approve the minutes and transcript of the October 5th, 2016 meeting.
Second.
All in favor?
Aye.
All opposed? Motion's adopted. At this point, we'll hear from our Executive Director, Kevin O'Toole.
Good morning, Chairman Barish, members of the board. Congratulations and welcome, Commissioner Young. Board staff looks forward to working with you. Over the past year, I've enjoyed, maybe a little bit too much, recognizing employees of the Gaming Control Board who have reached the milestone of 10 years of service to our agency. And we've recognized quite a few, which is a compliment to our agency. Today, I would like to recognize 2 additional anniversaries that are very important. Those are milestones regarding the 10-year anniversaries of the opening of the 2 first casinos in the Commonwealth of Pennsylvania. This past Monday, November 14th, Mohegan Sun Pocono observed its anniversary of its opening of its casino in Plains Township near Wilkes-Barre in Luzerne County. And in December, specifically on December the 19th, Parks Casino will be celebrating its 10th year anniversary of opening its casino in Bensalem Township in Bucks County. At that juncture 10 years ago, these new casinos offered just slot machines, and both were housed in temporary facilities within their racetrack grandstands. Each has since invested significant capital and moved into permanent facilities, added significant numbers of table games, expanded and modified multiple times their gaming floors, and added non-gaming amenities, including lounges and restaurants. Mohegan Sun Pocono also built a full-service hotel with expanded meeting space and a conference center. Mohegan and Parks have both become significant economic engines in their respective areas, jointly employing 3,800 persons, spending $110 million annually with other businesses in Pennsylvania for goods and services, and generating to date over $3.3 billion in tax revenue from the play of slot machines and table games. And most importantly, they have contributed millions of dollars to local charities. While I am describing the achievements of just these two casinos due to their significant anniversaries, I also want to note that the other 10 casinos in operation in Pennsylvania have similar stories of the impacts both in their local communities and statewide. Collectively, all 12 casinos employ over 18,000 persons at the present time and purchase approximately $400 million annually from Commonwealth businesses for goods and services. While we, of course, are first and foremost regulators, and we remain diligent in ensuring that Pennsylvania casinos operate with the highest integrity, I think it is important at this time to acknowledge in a public context both the ownership and the management teams at Mohegan and Parks for a job well done in helping to launch this industry and propelling it to one of the strongest gaming jurisdictions in the United States. Thank you.
Next, Director of Human Resources, Claire.
Good morning, Chairman, board members. The Office of Human Resources has two motions for your consideration today. The first motion before you is relative to the hiring of two individuals. Mr. Gary Rodriguez and Ms. Kara Jeffries have been selected for positions at the PGCB. Mr. Rodriguez has been selected as a casino compliance representative assigned to the Rivers Casino, and Ms. Jeffries has been selected as an administrative assistant supporting the Bureau of Investigations Enforcement and the Office of Enforcement Counsel. Both Mr. Rodriguez and Ms. Jeffries have completed the PGCB interview process, background investigation, and drug screening, and are recommended for hire by the respective Bureau directors. Unless you have questions, I ask for a motion approving the hires as indicated.
May I have a motion?
Mr. Chairman, I move that the board approve the applicants as proposed by the Director of Human Resources.
Second. All in favor?
Aye.
All opposed? The motion's adopted.
The second motion seeks to amend the PGCB classification and compensation structure. As you are aware, the current PGCB classification and compensation structure was originally adopted by the board in January of 2010 based on a comparison of data across public sector markets. The last increase to the ranges occurred in 2014 in order to stay consistent with pay ranges in other Commonwealth agencies. Effective October 1st, 2016, the Commonwealth Standard Pay Schedule, which is the primary comparator for our pay ranges, was adjusted, resulting in the PGCB pay ranges being below pay ranges for comparable positions in other administrative agencies. Based on my analysis of this comparative benchmark data, it is recommended that the PGCB age the compensation structure for the executive pay ranges by 4% and the non-union management pay ranges by 4.5%, with an effective date of October 1st, 2016. Such a change will result in the PGCB pay ranges remaining competitive with and comparable to the Commonwealth's standard pay schedule. These increases will apply to all but the maximum salary amount of the top pay range at the agency. For that pay range, executive pay range GE05, the maximum salary within the range will remain where it was set by the board in 2010. I would be happy to answer any questions regarding the proposed changes to the compensation structure.
Thank you. Are there any questions or comments from the board on this matter? May I have a motion?
Mr. Chairman, I move that the board approve the amendment to the PGCB classification and compensation structure as proposed by the Director of Human Resources.
Second.
All in favor?
Aye.
All opposed? Motion's adopted. Thanks, Claire.
Thank you.
Next, Dave Wren, Director of Financial Management.
morning, Chairman and members of the board. I'm here today to provide an overview of the board's budget request for fiscal year 2017-18 and request your consideration of approval of that budget. The proposed request is $41,665,000 for administration and $2 million for statutorily mandated local law enforcement grants. Funding for the board supports oversight of over 26,400 slot machines and 1,200 table games operating at 12 casinos throughout the Commonwealth. Last fiscal year, the gaming industry returned just under $1.4 billion in tax revenue to the Commonwealth. Overall, the budget request is $1.5 million, or 3.7% higher than the current fiscal year. The increase is principally the result of rising personnel costs. Next year, we'll see a 12.4% increase in pension rates to 32% of salaries, contractual salary increases, and a 4.4% increase to health benefit costs. The board's budget includes $36.3 million for personnel and benefits and $5.3 million for operating and fixed asset expenses. Personnel expenses comprise 87% of the overall budget request and include funding for 298 positions. The benefit rate is equivalent to 73.6% of salary expenses. The operating and fixed assets budget at $5.3 million is 13% of the overall request. A majority of these expenses are for real estate leases, investigative expenses, and telecommunications and data costs. The proposed budget would be funded through a combination of $5,755,000 in restricted revenue, which includes application and license fees and chargebacks of gaming lab costs to manufacturers, which are collected by the board, and $35,910,000 in drawdowns from escrow accounts funded by casino operators. That concludes my presentation of the budget. I'd be happy to take any questions. Otherwise, I would appreciate your consideration of a motion to approve the 2017-18 budget request.
Are there any questions or comments for the board?
One quick question. Thank you, Mr. Chairman. Dave, what's our current head count in the Gaming Control Board versus maybe the last 2 or 3 years? Do you have that information handy?
I do. It's been we averaged about 298 last year. I think we'll be at 297 after the 2 people that were hired today. Several years ago, we were over 310 people to as high as 324 about 4 or 5 years ago, I can recall.
Great. Thank you.
Other questions? Okay. May I have a motion?
Mr. Chairman, I move that the board adopt the 2017-2018 proposed budget request as described by the Office of Financial Management.
Second.
All in favor?
Aye.
All opposed? The motion's adopted. Thank you, David. Doug Sherman, Chief Counsel.
Good morning, Chairman, members of the board. Our first agenda item relates to a statement of policy, which Assistant Chief Counsel Susan Yoakum is here to present.
Good morning, Chairman, members of the board. The policy statement before you today is Policy 125-202. It will allow for the issuance and redemption of gaming vouchers at table games. Currently, cashable vouchers can only be used for slot machine and electronic table games. This will allow patrons to, this statement of policy will allow patrons to cash in those vouchers at a table game in exchange for chips. It will additionally allow patrons who don't wish to walk away from the table with chips to exchange those chips for a gaming voucher. This SOP will impact the calculation of gross table game revenue. We've amended how that formula is calculated and have also included provisions requiring operators to update their internal controls over the revenue audit process to account for tickets at table games. For any facility that would like to offer ticket redemption at tables, we will require a test period. And then once we get a few of operators who've gone through the test period process, I will be coming before you again with a proposed rulemaking, which will account for any issues that we've discovered during the implementation process. I'd be happy to answer any questions you may have.
Are there any questions from the board? May I have a motion?
Mr. Chairman, I move that the board issue an order to adopt Statement of Policy number 125-202 as described by the Office of Chief Counsel.
Second.
All in favor?
Aye.
All opposed? Motion's adopted. Thank you.
Today, we have 3 petitions before you for consideration. A hearing was held in one of those just a short time ago. The remaining 2 petitions will be decided based upon the existing record by agreement of the parties. In each of the matters, the board has, in advance of this meeting, been provided with all documents filed in the record. The first petition before the board is that of Pennsylvania State University's petition to possess 4 slot machines and 4 non-electronic table games so that it may create a small casino environment for use in its School of Hospitality Management. The Office of Enforcement Counsel, as indicated earlier today, does not have objection to the petition, subject to a set of conditions which go to ensuring that the game equipment is secure and under proper surveillance. As the matter has been heard by the board and the full record has been provided, it's now ripe for consideration and a motion by the board.
Are there any questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board grant Penn State University's petition to possess slot machines and non-electronic gaming tables as described by the Office of Chief Counsel and with the conditions which will be outlined in the board's order.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
The next matter is Pinnacle Entertainment and Washington Trotting Association's joint petition for approval of a parent services agreement. By way of background, in July of 2016, Washington Trotting Association, Pinnacle Entertainment, and other parties involved in the transaction filed a joint petition for change of control of the Meadows Casino. The board approved that change of control on September 7th, 2016, with a series of conditions, including one requiring that within 30 days of closing on the purchase agreement, Washington Trotting Association and Pinnacle, the new parent company, would obtain approval of its fully executed parent service agreement. Pinnacle and WTA had filed the current request, as I said, September 28th of 2016, and the agreement sets forth the services that Pinnacle will provide to the Meadows Casino. The agreement sets forth that in exchange for a fee paid to WTA, Pinnacle will provide certain services to the Pennsylvania property, including marketing and advertising, management of corporate-wide finances, strategic planning, risk management, procurement of gaming and non-gaming equipment and services, and certain accounting and human resource services. The Office of Enforcement Counsel has not objected to the request, subject to 5 conditions being imposed. The conditions generally require that the board be notified of any changes to or termination of the agreement, that proper licensure of Pinnacle employees occur, and that certain positions required by the board's regulations remain on site. And those are essentially surveillance functions, credit functions, things that need to be done at the property with high visibility. With that explanation, the matter is ready for the board's consideration of a motion.
Any questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board grant the joint petition of Pinnacle Entertainment, Inc. and Washington Trotting Association, LLC, as described by the Office of Chief Counsel, and with conditions which will be outlined in the board's order.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
The final petition before the board pertains to Ryan Kiger's request to make early reapplication for a gaming employee permit. By background, Mr. Kiger was issued a gaming employee permit in September 2010 and worked as a security officer at the Rivers Casino. In July 2013, he filed a renewal application for his permit, and during the course of that background investigation, it was determined that he was non-compliant with Department of Revenue requirements. As a result, the board issued an order on September 17, 2014, denying his renewal and barring him from reapplying for a permit for a period of 5 years absent board authorization. Mr. Kiger has now indicated that he is current with his obligations to the Department of Revenue and requests permission to reapply for a permit to be employed in the gaming industry. The Office of Enforcement Counsel has indicated that it has confirmed that he is in fact compliant, and therefore there's no objection to the relief requested. That's the relief to allow him to reapply early. That's now before the board and ready for consideration.
Thank you. Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board grant the petition of Ryan Kiger seeking early reapplication for a gaming employee occupation permit as described by the Office of Chief Counsel.
Is there a second?
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
Okay, next, presenting withdrawals and reports and recommendations is Deputy Chief Counsel Steve Cook.
Morning. The board has received several unopposed petitions to withdraw applications or surrender the credentials of the following individuals and entities: Dante Hill, Timothy Jansen, Ryan Langdon, Roger May, NGA Acquisition Company, LLC, NGA Blocker, LLC, NGA Holdco, LLC, NGA Novotco, LLC, NGA Voteco, LLC, Ira H. Raphaelson, Walter Daniel Redding, Chiara Baroli, Carlo Ferrari Ardacini, Charles Bauer, and Carolyn Bauer. The Office of Enforcement Counsel has no objections to any of these petitions, and as a result, if the board grants same, they'd be doing so without prejudice to each of these parties.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board issue orders to approve the withdrawals and surrenders as described by the Office of Chief Counsel.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
Next before the board are 6 reports and recommendations received from the board's Office of Hearings and Appeals. In advance of this meeting, the board's been provided with the reports and recommendations as well as the evidentiary record in each proceeding. Additionally, each person or entity subject to the reports have been notified that the board would be taking the matter up today and that they could come forward and briefly address the board. If any of these persons are present and do wish to address the board, I'd ask them to come forward when their matter is called. The first report and recommendation pertains to Karen Garcia. In April of 2016, Ms. Garcia submitted an application for a gaming permit seeking work as a table games dealer at the Sugar House Casino. On June 6, 2016, the Office of Enforcement Counsel issued a notice of recommendation of denial of Ms. Garcia's application, given she was convicted in New Jersey of a third-degree drug-related criminal offense in 2009, rendering her ineligible to receive a gaming permit in Pennsylvania under the Gaming Act. Ms. Garcia also failed to disclose the conviction in her application. Specifically, in 2009, she pled guilty to conspiracy to distribute cocaine. A hearing in this matter was held on August 18, 2016. Both Ms. Garcia and the Office of Enforcement Counsel appeared, offering evidence. Subsequently, a report and recommendation was issued by the Office of Hearings and Appeals, and in that report and recommendation, the hearing officer recommends that the application be denied as Ms. Garcia is statutorily ineligible to receive a gaming permit. And that's the recommendation before the board.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board adopt the report and recommendation issued by the Office of Hearings and Appeals regarding the gaming employee occupation permit of Karen Garcia as described by the Office of Chief Counsel.
Second.
All in favor? Aye. All opposed? The motion's adopted.
The next report and recommendation pertains to Deshaun Green's petition to lift the suspension of his non-gaming employee registration. Mr. Green was issued a non-gaming employee registration on December 3rd, 2014, and worked as a steward in a restaurant at the Parks Casino prior to his termination from that position in early 2015. Subsequent to his termination, he maintained his non-gaming registration, and in June 2015, the Office of Enforcement Counsel filed a complaint to suspend that registration after learning Mr. Green had been charged with criminal offenses in 2 separate instances. Specifically, in February of 2015, he was arrested and charged with retail theft after allegedly stealing over $200 in clothing from a Walmart store. A month later, in March of 2015, he was arrested and criminally charged after engaging in a physical altercation with his then-girlfriend. On November 18, 2015, the board suspended Mr. Green's registration until at least resolution of these criminal charges. Mr. Green is now requesting that the board lift the suspension, averring that the criminal matters have been resolved. OEC objects to the lifting of the suspension because they were both resolved by way of guilty pleas. A hearing in this matter was held on July 26th. Despite receiving proper notice, Mr. Green did not appear at that hearing, and it was held in his absence. As a result, there was no mitigating evidence put into the record, and the hearing officer's recommendation is that the suspension, in fact, remain in place, as the charges that caused the suspension have now resulted in convictions.
Any questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board adopt the report and recommendation issued by the Office of Hearings and Appeals regarding Deshaun Green's petition to lift the suspension of his non-gaming employee registration as described by the Office of Chief Counsel.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
Robert S. Lee's report and recommendation is the next matter before the board today. Mr. Lee was issued a non-gaming employee registration on July 25, 2016, and worked as an EVS attendant at the Valley Forge Casino Resort. On August 2, 2016, the Office of Enforcement Counsel filed a request for an emergency suspension of Mr. Lee's non-gaming registration after learning that, while off duty, he had been arrested and charged with several criminal offenses, which included a felony count stemming from allegations that he forcefully stole a purse from a female victim. As a result of this arrest, the executive director issued an emergency suspension as requested by OEC. A hearing on the validity of the emergency suspension was held on August 23rd. Despite receiving proper notice, Mr. Lee did not attend or present any evidence in support of his position that the suspension not be put in place. As a result, the hearing officer's recommendation is, in fact, that the suspension remain in place.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board adopt the report and recommendation issued by the Office of Hearings and Appeals regarding the suspension of Robert S. Lee's non-gaming employee registration as described by the Office of Chief Counsel.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
The next matter before the board today pertains to a joint petition filed by Mount Airy No. 1 LLC and NNL Transportation Incorporated, requesting that NNL Transportation be removed from the board's prohibited gaming service provider list and denied gaming service provider list. By way of background, NNL Transportation has provided snow removal services to the Mount Airy Casino. Related to that, it filed an application for a gaming service provider certification. After filing its application, NNL subsequently petitioned to withdraw it, and OEC did not object to the withdrawal petition so long as it was with prejudice, as they were in the midst of an investigation. As a result, in August of 2013, the board issued an order withdrawing NNL's application with prejudice. However, upon receipt of the board order, the Bureau of Licensing not only marked NNL's application as withdrawn, but also placed it on both the prohibited gaming service provider list and denied gaming service provider list. And as a result of its placement on those lists, NNL and Mount Airy filed this petition to be removed from the lists, as they were not put on notice of that action. The Office of Hearings and Appeals held a hearing in this matter on March 19th of 2015, with both parties attending. After the hearing, a briefing schedule was issued and both parties filed briefs as well. NNL essentially argued that the withdrawal, even with prejudice, did not warrant placement on these lists, and in fact the board regulations at the time did not provide for such action. OEC objected to the request, specifically arguing that placement of entities whose applications were withdrawn with prejudice on the list is necessary to provide notice to the casinos in the Commonwealth that they can't do business with such entities. On August 20th, 2015, a report and recommendation was issued in this matter recommending that NNL be removed from both of these lists, and at that time, given they were not put on notice about placement on the list. The August 2015 report and recommendation was before this board on November 18th, 2015, but notwithstanding earlier statements that NNL was considering refiling an application were to be removed from the list and was willing to be regulated as a gaming service provider, during the meeting, counsel for petitioners indicated that they did not believe a snow removal company was a gaming service provider under the board's regulations. Based upon the petitioner's new argument, the board tabled the matter and referred it back to Hearings and Appeals for a hearing on the second issue about whether a snow removal company fell under the gaming service provider definition in the board's regulations. A hearing on that issue was held on December 3rd, 2015, with both petitioners and OEC appeared, presenting evidence to support their positions. Supplemental briefs were also once again filed. Petitioners again argued in those proceedings that snow removal services are conducted entirely outside of a licensed facility. The employees do not set foot within the licensed facility, and their services are not directly related to the operation of a casino, and therefore the petitioners do not believe NNL is required by the board's regulations to become a gaming service provider. OEC, on the other hand, argued that, in fact, a snow removal company does provide a service necessary to the operation of a casino, and because of that, fell under the board's regulations. As a result of these protracted proceedings, the board today has two questions before it for consideration. First, should NNL be removed from the prohibited gaming service provider list and denied gaming service provider list? And second, is NNL, a company which provides snow removal services to a licensed facility in the Commonwealth, a gaming service provider? I would note for the record that Michael Sklar, who is counsel for both NNL and Mount Airy, is present. I believe he's available to answer questions if the board so chooses, but the record is quite complete. I don't think he has much more to say unless the board has questions. And now the matter is ripe for the board's consideration.
Just for the record, I want to make certain, Mr. Sklar, are you content to allow us to proceed, or do you have any statement you want to make? Apparently, you have a statement you want to make.
No, as Steve said, the record is complete. You have all of our arguments.
Okay. Thank you very much. May I have a motion regarding NNL's request to be removed from the board's prohibited gaming service provider list?
Mr. Chairman, I move that NNL Transportation, Inc. be immediately removed from the board's prohibited gaming service provider list and denied gaming service provider list, and, notwithstanding the previous gaming service provider application being withdrawn with prejudice, that it once again be allowed to make application as a gaming service provider if it so chooses.
Second.
All in favor?
Aye.
All opposed? The motion's adopted. Now, may I have a motion regarding the question of whether NNL, as a provider of snow removal services, should be considered a gaming service provider under the board's regulations?
Mr. Chairman, I move that the board find that NNL Transportation, Inc., as a company providing snow removal services to a licensed facility, is a gaming service provider under the board's regulations, as it is providing a service for use in the operation of a licensed facility.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
Next before the board is Brittany Robinson's report and recommendation. On March 30th, 2016, the Office of Enforcement Counsel filed a complaint requesting that Brittany Robinson be placed on the board's excluded persons list, alleging that she assisted her underage friend, Correa Fort, gain access to the gaming floor at the Sands Bethworks Casino. Ms. Robinson requested a hearing in this matter, which was held on July 12, 2016. Despite receiving notice, Ms. Robinson did not attend that hearing, and it was held in her absence. OEC at the hearing offered the testimony of the board's CCR supervisor at Sands, as well as documentary evidence. OEC's evidence showed that on March 8, 2016, Ms. Robinson arrived at the casino with Ms. Fort, an individual under 21 years of age, and another of-age male. The CCR supervisor testified that surveillance video shows the three individuals in the parking garage at Sands prior to their entering the casino, and that Ms. Robinson can be seen providing Ms. Fort with something, however, it is not clear what was being provided. The video surveillance then shows that the individuals split up, with Ms. Robinson entering the casino through the bus entrance, while Ms. Fort and the other individual, the male individual, entered the casino at the main entrance. According to the testimony, while at the main entrance, Ms. Fort and the male are asked for identification, with security scanning both IDs which were presented. The records of the scanners used, which was put into the record as well, shows that Ms. Robinson's driver's license was one of the cards or driver's licenses scanned at the main entrance, although according to the testimony, the video does not show Ms. Robinson actually entering that entrance. Thereafter, Ms. Robinson and Ms. Fort were found sitting together on the gaming floor. After hearing all of the evidence presented, a report and recommendation was issued by the board by a board hearing officer recommending that Ms. Robinson not be placed on the board's exclusion list. Specifically, the hearing officer took issue with OEC's failure to place the actual surveillance video into the record, rather relying solely on the testimony of the CCR supervisor who viewed the video. And that is the recommendation before the board.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board reject the report and recommendation issued by the Office of Hearings and Appeals regarding the placement of Brittany Robinson on the PGCB's involuntary exclusion list, as described by the Office of Chief Counsel, and that Ms. Robinson be placed on the board's exclusion list for a period of at least 1 year, after which she may petition to come off the list.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
The final report and recommendation before the board today pertains to Roseanne Stabile. On April 5th, 2013, the board placed Ms. Stabile on the involuntary exclusion list after it found that during September of 2012, she was involved in a scheme with 2 other patrons and a table games dealer at Harrah's, Philadelphia, which resulted in her collecting winnings which she was not entitled to receive. Ms. Stabile pleaded guilty to charges related to this conduct and was sentenced to 2 years of probation in order to make restitution in excess of $3,500. On May 9th, 2016, Ms. Stabile filed a petition requesting to be removed from the exclusion list, stating that the incident was a misunderstanding and that she was in the wrong place at the wrong time and has not been involved in any criminal activity since being placed on the list. A hearing was held on August 2nd, 2016. Despite receiving proper notice, Ms. Stabile failed to attend the hearing. It occurred in her absence, and of course there was no mitigating evidence put into the record, and as a result the recommendation of the hearing officer is that she in fact not be removed from the exclusion list.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board adopt the report and recommendation issued by the Office of Hearings and Appeals regarding the petition of Roseanne Stabile to be removed from the PGCB involuntary exclusion list as described by the Office of Chief Counsel.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
And that concludes all matters of the
Thank you
Office of
very
Chief
much.
Counsel.
Next up, Sue Hensel, Bureau of Licensing.
Thank you, Chairman Barish and members of the board. Before the board today will be 1 table game manufacturer renewal license and 1,034 principal key gaming and non-gaming employee applicants. In addition, there will be consideration of 15 gaming service provider applicants. The first matter for your consideration is the renewal of the United States Playing Card Company's table game manufacturer license. The United States Playing Card Company is a Kentucky-based enterprise that manufactures several lines of playing cards as well as card-dealing shoes. The Bureau of Investigations and Enforcement has completed its investigation of the company, and the Bureau of Licensing has provided you with a background investigation and suitability report. I have provided you with a draft order for this entity and ask that the board consider the order to renew the table game manufacturer license.
Questions or comments from Enforcement Council?
Enforcement Council has no objection.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the renewal of the United States Playing Card Company's table game manufacturer license as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
Next for your consideration is the approval of principal and key employee licenses. Prior to this meeting, the Bureau of Licensing provided you with a proposed order for 3 principal and 5 key employee licenses. I ask that the board consider the order approving the licenses.
Comments from Enforcement Council?
Enforcement Council has no objection.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the issuance of principal and key employee licenses as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
There are also temporary principal and key employee licenses for your consideration. Prior to this meeting, the Bureau of Licensing provided you with an order regarding the issuance of temporary licenses for 5 principal and 26 key employees. I ask that the board consider the order approving these licenses.
Enforcement Council?
Enforcement Council has no objection.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move the board approve the issuance of temporary principal and key employee credentials as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
Next, there are gaming permits and non-gaming registrations. Prior to this meeting, the Bureau of Licensing provided you with a list of 681 individuals to whom the Bureau has granted temporary or full occupation permits, and 228 individuals to whom the Bureau has granted registrations under the authority delegated to the Bureau of Licensing. I ask that the Board consider a motion approving the order.
Enforcement Council has no objection.
Questions or comments from the board? May I have a motion?
Chairman, I move that the board approve the issuance of gaming employee permits and non-gaming employee registrations as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
Also, there are recommendations of denial for 2 gaming employee applicants and 1 gaming service provider applicant. In each case, the applicant failed to request a hearing within the specified time frame. The Bureau of Licensing has provided you with orders addressing the applicants, who the Office of Enforcement Counsel has recommended for denial. I ask that the Board consider a motion approving the denials.
Enforcement Council continues to request denial in each instance.
Thank you. Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board deny the gaming service provider and gaming employee applications as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
Also for your consideration are withdrawal requests for gaming and non-gaming employees. In each case, the permit or registration is no longer required. For today's meeting, I have provided the board with a list of 62 gaming and 21 non-gaming employee withdrawals for approval. I ask that the board consider the orders approving the list of withdrawals.
Enforcement Council has no objection.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the withdrawals as described by the Bureau of Licensing.
Second?
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
Next, we have an order to certify the following gaming service providers: Go-Go Bus Tours, Inc., Keystone State Distributing, Inc., Macintosh Linen and Uniform Rentals, Inc., doing business as Macintosh Services, Inc., and Power Promotions, LLC. I ask that the board consider the order approving these gaming service providers for certification.
Enforcement Council has no objection.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the applications for gaming service provider certification as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
Finally, for your consideration, are gaming service provider registrations. The Bureau of Licensing provided you with an order and an attached list of 11 registered gaming service provider applicants. I ask that the board consider the order registering these gaming service providers.
Enforcement Council has no objection.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the applications for gaming service provider registrations as described by the Bureau of Licensing.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
That concludes the Bureau of Licensing's matters.
Thank you, Susan. Next up, Office of Enforcement Counsel.
The Office of Enforcement Counsel will present 17 matters for the board's consideration today, consisting of 8 consent agreements, 2 revocations, and 7 involuntary exclusions. The first matter on the OEC portion of the agenda is a consent agreement between the Office of Enforcement Counsel and Mr. Kamashok. The matter will be presented by Assistant Enforcement Counsel Dustin Miller.
Thank you.
Good morning, Chairman Barish, members of the board. Dustin Miller on behalf of the Office of Enforcement Counsel. This consent agreement arises from a petition the Office of Enforcement Counsel filed to place Mr. Kamashok on the board's excluded persons list on December 8, 2015. The Office of Enforcement Counsel filed the petition against Mr. Kamashok because on October 24, 2015, Mr. Kamashok pass-posted 4 wagers while playing roulette at Parks Casino, resulting in Mr. Kamashok receiving $1,226 to which he was not entitled. After being approached by Parks Casino security personnel, Mr. Kamashok made restitution of $500. Mr. Kamashok was subsequently permanently evicted from Parks Casino for his actions. The terms of the consent agreement call for Mr. Kamashok to be placed on the board's exclusion list for a minimum period of 3 years from his placement on the exclusion list. Mr. Kamashok shall be barred from petitioning the board for early consideration for his removal from the exclusion list during the 3 years from the date of his placement on the exclusion list. Mr. Kamashok shall be permitted to file a petition requesting removal from the exclusion list at any time after the 3 years from the date of his placement on the list. Terms of the agreement also require Mr. Kamashok to make full restitution of $726 to Parks Casino. Mr. Kamashok is barred from requesting a hearing concerning the removal from the date of from 3 years from the date of his placement on the exclusion list. The board's placement of Mr. Kamashok on the exclusion list shall have the effect of requiring the exclusion of Mr. Kamashok from all licensed facilities in the Commonwealth of Pennsylvania. Mr. Kamashok is also prohibited from collecting any, in any manner or in any proceeding, any winnings or any losses arising from as a result of any gaming activity for the entire period of time that he's on the board's exclusion list. And as a result of Mr. Kamashok's placement on the exclusion list, the following information will be made available to the public through the board's website. Mr. Kamashok's name, physical description, photograph, birth year, and also a short description of the events that led to his placement on the exclusion list. This time, the Office of Enforcement Counsel would ask the board to entertain a motion to approve this consent agreement.
I trust Mr. Kamashok is not present.
Thank you.
Any questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the consent agreement between the Office of Enforcement Counsel and Kamashu Kamashok as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? Motion's adopted. Thank you.
The next matter on the agenda for the board's consideration is a consent agreement between the Office of Enforcement Counsel and Mount Airy No. 1 LLC, doing business as Mount Airy Casino Resort. This matter will be presented by Assistant Enforcement Counsel David Tepper.
Before we proceed, if anybody other than an attorney is going to be speaking for Mount Airy, they should stand and be sworn in. And could you state your name and spell it for the court
Dennis
reporter?
Asselta, A-S-S-E-L-T-A.
Thank you.
Good morning, Chairman Barish, members of the board. David Tepper, T-E-P-P-E-R, with the Office of Enforcement Counsel. This proposed consent agreement involves Mount Airy improperly replacing damaged cards. On May 25th, 2015, cards used in the play of blackjack were damaged in a shuffler. Table game staff took the shuffler to the pit stand where they replaced the damaged cards, replacing a damaged 8 of spades with a fresh new 7 of spades. The cards were returned to play for approximately 13 hours. At this time, the Office of Enforcement Counsel requests that the board approve this consent agreement between the parties. The terms of the settlement include that within 5 days of the board's order approving the consent agreement, Mount Airy shall pay a civil penalty of $7,500. Also within 5 days of the board order, Mount Airy shall pay the board $2,500 for the costs incurred by OEC, BIE, and other board staff in connection with the investigation of this matter. And if you have any questions, we'd be happy to address them at this time.
Does Mount Airy have anything they wish to say at this time?
Just very briefly, good morning. Michael Sklar on behalf of Mount Airy, S-K-L-A-R. With me is Dennis Asselta, who's the Director of Table Games at Mount Airy. And if Dennis can just describe the measures that were taken following this incident to try to prevent similar incidents from occurring in the future.
Thank you.
Beginning with the day after the incident, I personally met with all supervisors and managers in the department, and I went over the regulation as well as the procedures we have in place. We have included this topic in our training for people who are dealers getting promoted into their supervisory role, and we have added this to one of the topics of our daily pre-shifts.
Thank you. Are there any questions from any board members? I have one. I noticed that this replacing of an 8 with a 7 then continued for 13 hours, and I just express my amazement that no one would have noticed that just from the laws of probability, that it wouldn't have become apparent that there were 2 7s and no 8.
Well, you know, it's an 8-deck shoe, number one. The alarming part is that in that amount of time, the machine never red lighted again, indicating a problem. You know, we use a shuffle machine with card recognition, which besides counting the cards, you know, visually looks at every card, and it should come up with a red light indicating, you know, you have an extra one of this or an extra missing that. That's the alarming part to me.
Do you have any idea? To me, just mathematically, it's kind of surprising.
Yeah.
Do you have any thought on why that happened? Or
I spoke to the people that come in and service our machines. You know, they're there 2 to 3 times a week to do preventive maintenance, and they agreed that a red light should have come up, and it could be down to something as simple as a piece of dust being on the camera lens or
I
whatever
see.
the case may be, and that's why it malfunctioned.
So there's no thought that two sevens didn't show up in the same hand at some point. Okay. Thank you very much. Any questions from the board? May I have a motion?
Mr. Chairman, I move that the board approve the consent agreement between the Office of Enforcement Counsel and Mount Airy Number 1 LLC as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? Motion's adopted. Thank you very much.
Next matter on the agenda for the board's consideration is a consent agreement between the Office of Enforcement Counsel and Mr. Robert Singh. This matter will also be presented by Assistant Enforcement Counsel David Tepper.
Good morning, Chairman Barish, members of the board. On November 30th, 2015, Robert Singh left his 22-year-old special needs son in a vehicle at Mount Airy for approximately 2 hours and 15 minutes. Mr. Singh was found playing blackjack after his special needs son was identified in the vehicle by Mount Airy personnel. Mr. Singh was charged by Pennsylvania State Police with 1 count of recklessly endangering another person and 1 count of disorderly conduct. At the district justice level, he pled guilty to 1 count of disorderly conduct. OEC engaged in negotiations with Mr. Singh by and through his attorney. Mr. Singh has entered into this consent agreement by which he agrees to be placed on the exclusion list for a minimum of 1 year, after which time he may petition for removal from the self-exclusion list. Mr. Singh's attorney has represented to me that he is unable to be present today due to an appearance in the Court of Common Pleas, but that he has discussed this consent agreement with his client and is in agreement with the terms. At this time, OEC requests that the board approve the consent agreement to place Robert Singh on the board's involuntary exclusion list, consistent with the terms set forth in the consent agreement, including that Mr. Singh's biographical information, a summary of his inimical behavior, and his photograph be placed on the board's public website.
Any questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the consent agreement between the Office of Enforcement Counsel and Robert Singh as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
Next matter on the agenda for the board's consideration is a consent agreement between the Office of Enforcement Counsel and Robin Grigg. This matter will be presented by Assistant Enforcement Counsel John Crow.
Good morning, Chairman, members of the board. John Crow, C-R-O-H-E, for the Office of Enforcement Counsel. The next matter for the board's consideration is a consent agreement reached between Robin Grigg, G-R-I-G-G, and the Office of Enforcement Counsel regarding Ms. Grigg's inimical activity at Rivers Casino. On May 12, 2016, River Security was notified by a Players Club supervisor that a guest was using different forms of identification to obtain players' cards. On March 16, 2016, it was discovered that Robin Grigg had obtained players' cards using invalid Arizona identification that was not issued by the state of Arizona. Ms. Grigg presented invalid Arizona identification that was not issued by the state of Arizona to Rivers Casino 4 times over the course of a 3-day period between March 10, 2016 and March 12, 2016. Ms. Griggs was subsequently permanently evicted from Rivers Casino and charged with 4 counts of violations concerning licenses. Ms. Grigg currently has a trial scheduled for December 1st. The Office of Enforcement Counsel respectfully requests that this board approve a consent agreement and the stipulations of settlement wherein Ms. Grigg has agreed to be placed on the board's excluded persons list for a minimum of 5 years, that she shall be barred from petitioning the board for early consideration of removal from the exclusion list for that 5-year period, and that she is barred from requesting a hearing concerning her removal from that exclusion list during this 5-year period. If the board approves the placement of Ms. Grigg on the exclusion list, Ms. Grigg's picture, physical description, and a summary of her inimical behavior will be placed on the board's public website. Ms. Grigg was represented by her counsel, Anthony DeLuca, during this negotiation, and I can answer any questions you may have. Thank you.
I trust Ms. Grigg is not present. Any questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the consent agreement between the Office of Enforcement Counsel and Robin Grigg as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
Next matter on the agenda for the board's consideration is a consent agreement between the Office of Enforcement Counsel and and Sands Bethworks Gaming LLC doing business as Sands Bethlehem. This matter will be presented by Assistant Enforcement Counsel Michael Rowland.
Morning, members of the board.
Morning.
Michael Rowland, ROL A&D with the Office of Enforcement Counsel. I believe we have a representative present for Sands. This next proposed consent agreement involves 2 incidents of failure to properly address table game issues at Sands Casino. Sands Security notified the Bureau of Casino Compliance that 10 playing cards from a blue deck were found commingled with the red decks of playing cards on Blackjack Table 109. The surveillance footage of the alleged procedural violation was reviewed, and it revealed that at 9:41 p.m., a Sands floor supervisor removed the blue decks of playing cards from the CSM shuffler. At 9:48, the dealer placed the red decks of playing cards into the same shuffler. And by 10:53 p.m., the dealer discovered a blue playing card commingled with the red decks of playing cards after the round was completed. A Sands table game pit manager counted the cards from the earlier removed blue decks, which were properly bagged, and reported that all the playing cards from the blue decks were present. However, at 1:05 a.m., 2 additional cards from the blue decks appeared in play. At this point, play was halted, and the red decks were reviewed. In total, there were 10 blue cards commingled with the red decks. A total of 194 rounds, or 935 hands, were dealt with commingled cards. This incident was self-reported by Sands. The second count, surveillance notified the Bureau of Casino Compliance about a procedure violation by a dealer at Sands. The dealer, who was assigned to Blackjack 204, failed to clear the throat of the shoe, leaving 1 blue deck card when he was placing the red decks in the shoe. Surveillance performed a review and provided that at 8:23 a.m., the dealer failed to clear the throat of the shoe. He then inserted the red decks. The blue card was discovered when it was produced as the burn card. The blue decks, which was missing 1 card at this point, were then placed in a separate shuffler. At approximately 8:32, the shuffler red lighted because of that missing card. A table game supervisor was called to address the shuffler issue, and he then approved a hand shuffle of the red decks on the table until the matter with the blue cards was resolved. The red decks, plus the 1 additional blue card at this point, were hand shuffled by the dealer and placed back in the shoe and put back into play. In total, 2 shoes were played after the blue card was used as the cut card. A total of 156 hands were dealt from 8:23 a.m. to 9:20 a.m. before the blue card was discovered and removed. And this incident was also self-reported by Sands. The Office of Enforcement Counsel requests that the board approve the consent agreement and stipulation of settlement entered into between the parties. Sands shall pay a civil penalty in the amount of $22,500 to the board within 5 days of the board's order approving this consent agreement. Sands shall pay the board $2,500 for costs incurred by OEC, BIE, and other related staff in connection with this matter. This also should happen within 5 days. Further, Sands shall immediately review policies and controls and provide training and guidance to its employees, which would minimize the opportunity for the occurrence of a similar incident in the future. If you have any questions, we'd be happy to take them at this point.
Good counsel for Sands, please identify yourself for the court reporter.
Yes, Scott Kramer, Dwayne Morris, representing Sands Bethlehem. Mr. Chairman, Commissioners, Madam Commissioner, Sands accepts the jurisdiction of the board and the Office of Enforcement Counsel and enters into this consent agreement voluntarily. I think it's noteworthy that this is the first penalty assessed for any gaming procedure irregularity against Sands Bethlehem. The petition explains the measures that are taken by Sands in response to the investigation and consent order, and they consist, as you may have read, of coaching and counseling sessions for all implicated persons, a retraining on the 126 shuffler for all personnel, that the shuffler has been moved from the blackjack games to another location, and there's been a change in the color of the cards approved by the board to create a more vibrant backing of the cards to prevent possibility of any visual errors in the future.
Thank you. Any questions or comments from the board?
I have one quick question. Mike, I heard you say that the blue deck shoe light went on when it was missing a card and they loaded the blue decks into the shoe. But I didn't hear, and maybe I just missed it, did the red deck shoe light go on because it had a blue card in it? Or was it not sensitive to the color?
It was not sensitive. These specific shufflers, which now Sands, I believe, has replaced at all of the blackjack tables, they're a bit antiquated and are unable to identify not only number but color of cards. So really the only time they red light is if there's a jam or if the shuffler itself is manually opened. Obviously that's problematic, and they've replaced it for that reason.
Thank you.
Sure.
Any other questions? May I have a motion?
Mr. Chairman, I move that the board approve the consent agreement between the Office of Enforcement Counsel and Sands Bethworks Gaming, LLC, as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? The motion's adopted. Thank you very much.
Mr. Chairman, I neglected to introduce our Sands representatives here today. There were no need for testimony, but I'd like to take that opportunity.
Please.
Here, we have Mr. Giuliani, who you all know, Mark Giuliani, President. We also have three directors, Jack Kennedy, Director of Table Games, Jeff Tomlinson, Director of Compliance, and Matt Forbes, Director of Security.
Thank you. Thank you very much.
Thank you.
The next matter on the agenda for the board's consideration is a consent agreement between the Office of Enforcement Counsel and Holdings Acquisition Co. LP, doing business as Rivers Casino. This matter will also be presented by Assistant Enforcement Counsel Michael Rowland.
Next proposed consent agreement involves unauthorized procedures which were conducted at Rivers Casino. Bureau of Investigations and Enforcement conducted an investigation related to an allegation that Rivers had offered 2 poker tournaments, which included a rule variation known as win the button, without the necessary approval from the PGCB. According to the board's regulations, and that's specifically 637A11C, a button shall be used to indicate the order in which the card shall be dealt and the order in which players shall bet in accordance with the following procedures. 1, at the commencement of play, the button shall be placed in front of either the first player to the right of the dealer, the player randomly determined by rank of a single card dealt. Thereafter, the button shall rotate around the table in a clockwise manner after each round of play. The Bureau of Gaming Operations reviewed the win the button modification and determined that the rule variation win the button was inconsistent with the board approved rules. Again, that's specifically 637A11C. The investigation ultimately revealed that on April 24th, 2015 and June 22nd, 2015, Rivers did in fact offer and conduct the win the button tournament. This was done without receiving required prior approval from the PGCB. Additionally, BIE discovered that Rivers advertised the Win the Button poker tournaments on 2 separate gaming websites. Both websites provided detailed information about the 2 poker tournaments. The Office of Enforcement Counsel requests that the board approve this consent agreement and stipulation of settlement entered into between the parties. Rivers shall pay a civil penalty in the amount of $20,000 to the board within 10 days of the board's order approving this consent agreement. Additionally, Rivers shall pay to the board $2,500 for the costs incurred by OEC, BIE, and other related staff in connection with this matter. Further, Rivers shall immediately review policies and controls and provide training and guidance to its employees, which will minimize the opportunity for the occurrence of a similar incident in the future. If you have any questions, we'd be happy to take them at this point.
Counsel for Rivers, could you identify yourself for the court
Yes,
report?
good morning, members of the Commission. John Donnelly on behalf of Rivers. Also with me is Danielle Cisneros, who's senior counsel, and I'm sure you met her before. This was just an error. It was the belief that this had been submitted. It wasn't submitted. They literally have hundreds of these tournaments, and these two particular tournaments were an oversight, and we do consent to the
Okay.
penalty.
Are there any questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the consent agreement between the Office of Enforcement Counsel and Holdings Acquisition Co. LP as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? The motion's adopted. Thank you for coming.
The next matter on the agenda for the board's consideration is a consent agreement between the Office of Enforcement Counsel and Holdings Acquisition Co. LP doing business as Rivers Casino. This matter will be presented by Assistant Enforcement Counsel Beth Manifesto.
Good morning. Beth Manifesto on behalf of OEC, MANIFESTO. We have for your consideration a consent agreement with Rivers based upon an underage gaming incident which occurred on March 25th of this year when security failed to card a 20-year-old woman. The underage woman was on the gaming floor for approximately 3 hours and 38 minutes. She did not consume alcohol at the casino. While she was on the gaming floor, she placed multiple bets at table games and engaged in slot play. She later exited the casino and then attempted to re-enter. At that time, she was carded by a different security officer. The security officer reviewed the photo identification, did not believe it belonged to the young woman in front of her. The young woman was taken to Rivers Secure Operations Center by Pennsylvania State Police, and eventually while there she admitted she was 20 years of age and the identification was not hers. The state police charged her with a third-degree misdemeanor for presenting false ID to law enforcement and 3 summary offenses under 1518. The Office of Enforcement Counsel requests that Rivers Casino be fined $10,000 by the board and additionally be assessed the $2,500 in administrative fees for BIE, OEC, and other staff regarding this matter. Each is to be paid within 5 days of the board's acceptance of the consent agreement.
Okay. Any comments?
Yes, John Donnelly again. As you know, Rivers has a stellar record. This was the first underage violation since November of 2015, so it broke that record. The young lady came in with an older companion and had her aunt's ID and presented it, got through the first times, and then when another guard caught it, and she continued to try to deceive everyone and ultimately admitted that she was 20.
Okay. Thank you. Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the consent agreement between the Office of Enforcement Counsel and Holdings Acquisition Company, LP, as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
Thank you.
The next matter on the agenda for the board's consideration is a consent agreement between the Office of Enforcement Counsel and Sugar House HSP Gaming LP, doing business as Sugar House Casino. This matter will be presented by Assistant Enforcement Counsel Jim Armstrong.
Good morning, Chairman. Commissioners, James Armstrong for the Office of Enforcement Counsel, the ARMSTRONG. Next matter on the agenda for the board's consideration is a consent agreement reached between the Office of Enforcement Counsel and Sugar House Casino in regard to 3 subjects on the board's self-exclusion list being permitted to gamble at Sugar House Casino. Commissioners, in the first incident, surveillance recordings revealed that a self-excluded individual entered Sugar House's poker room at 12:01 a.m. on January 15th and played poker for several hours. He played poker at various tables, buying in 4 times, each time losing all of his chips. At 4:20 a.m., the self-excluded individual attempted to make cash withdrawals from 2 ATMs, but his card was declined both times. He left the poker room and went to the casino where he attempted to utilize the cash advance services when his self-excluded status was determined by the cashier. Sugar House Security was advised of the self-excluded individual and responded to the cash advance service booth and took custody of the subject and escorted him to the back of the house. Surveillance coverage showed that before they reached the security office, a security officer released the self-excluded individual and allowed him to leave the casino without an escort. Security did not notify the Sugar House Surveillance Department, the Bureau of Casino Compliance, or the State Police in regard to the self-excluded individual. This matter was discovered through a compliance review conducted by the Bureau of Casino Compliance. The security officer received a final written warning from Sugar House. The self-excluded individual placed himself on the board's self-exclusion list on April 20th of 2014, and it was a lifetime self-exclusion. Commissioners, in the second incident on June 24th, a self-excluded individual entered Sugar House at 3:22 p.m. and was discovered at 4:24 p.m. at the Rush Rewards desk. Prior to discovery, the self-excluded patron played slot machines and the Big Six game in Pit 10. Security officers responded to the Rush Rewards desk and took custody of the self-excluded individual. She was turned over to Pennsylvania State Police, who cited her for trespassing and escorted her off the property. A subsequent review by Sugar House determined that the self-excluded individual violated the board's self-exclusion list on the previous date. On June 22nd, the self-excluded individual successfully accessed services at the main cage through check cashing transactions because the cashiers did not review or follow proper procedures regarding self-excluded persons' identification. In all, the self-excluded individual cashed 2 checks and played on 16 different slot machines in different gaming zones. The 2 cashiers received level 2 warnings. For this incident, the self-excluded individual placed herself on the board's self-exclusion list on April 5th of 2014, and it was a lifetime exclusion. Finally, in the third incident, Commissioners, the self-excluded individual entered Sugar House at 6:35 p.m. on June 30th and began playing a slot machine. At 7:23 p.m., the slot machine the self-excluded individual was playing recorded a jackpot in the amount of $1,474. At 7:24 p.m., the player services agent arrived to verify and pay the jackpot. The player services agent received the self-excluded individual's identification while he was completing the jackpot slip, but did not scan the self-excluded individual's identification to determine if he was excluded or self-excluded. The player services agent paid the self-excluded individual the $1,474 jackpot. At 7:36 p.m., the self-excluded individual left Sugar House. The patron's self-exclusion status came to light when the player services agent returned to the jackpot room and checked the self-excluded individual's identification in the Konami Casino Management System. The player services agent notified his manager, who notified the Bureau of Casino Compliance. Since the self-excluded individual left the property before the jackpot could be confiscated, the player services agent's manager took $1,474 from the player services agent's slot wallet and turned it into the self-exclusion confiscated funds log at the main cage. The self-excluded individual placed himself on the board's self-exclusion list on March 15th of 2015 through the 1-year self-exclusion and remains on the board's self-exclusion list. The player services agent received a level 2 written warning for his conduct in this incident. Commissioners, the Office of Enforcement Counsel and Sugar House Casino respectfully request the board to approve the consent agreement and stipulation of settlement, which requires Sugar House to maintain policies and training to prevent similar violations of the board's self-exclusion list. For Sugar House to pay a civil penalty of $22,500, as well as additional costs of $2,500 for costs incurred by the Office of Enforcement Counsel and other staff in connection with the investigation, assessment, and settlement of these incidents. We'll be glad to answer any questions.
Have any comments, Mr. Donnelly?
No. I'd like to introduce, to the commission, Dean McBride, who's a new employee of Sugar House, relatively new, is the vice president of gaming. He's got, first time he's been here as well, 20 years of service with the old Harris, real Harris, before it became Harris, that we all know, and Hilton and Caesar. So just wanted to introduce Dean, who's going to be taking over that aspect. I do want to say 2 things, Mr. Chairman, if I could. The first one, the man who came back and used the ATM, the person who was involved from Sugar House is no longer with us, but what he was told was that the man said he was using the ATM because he's out of gas, and that our employee was not aware he'd been in the casino at the time that happened. The other persons, as you're aware, were all received level 2 warnings, which are serious warnings with regard to this matter. That's all I have. Thank you.
Thank you. Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the consent agreement between the Office of Enforcement Counsel and Sugar House HSP Gaming, LP, as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? The motion's adopted. Thank you very much.
The next 2 matters on the agenda consist of enforcement actions in which the Office of Enforcement Counsel has filed complaints seeking the revocation of 1 gaming permit and 1 non-gaming registration issued to individuals by the board. Each complaint has been filed with the Board's Office of Hearings and Appeal and properly served upon the individual named in the complaint. The individual named in each complaint failed to respond within 30 days as required by Board regulation. As a result, the Office of Enforcement Counsel filed a request for default judgment and properly served the same upon each named individual. Thereby, the facts in each complaint are deemed admitted. All filed documents have been provided to the Board, and the matters are presently ripe for Board consideration. In each instance, we will read a brief summation of the facts and request the appropriate Board action.
Thank you.
Chairman Commissioners, James Armstrong for the Office of Enforcement Counsel. First matter is a motion to consider revocation of Benson Johnson's non-gaming employee registration. Commissioners, on February 22nd, the Office of Enforcement Counsel filed a complaint to revoke Mr. Johnson's non-gaming employee registration. The basis for the complaint was Mr. Johnson's conduct amounting to theft while employed as an EVS attendant at Sugar House Casino. Mr. Johnson, while on duty, was observed on surveillance coverage, finding the patron's lost cellular phone and not turning it in to the casino's lost and found. After security confronted him, Mr. Johnson returned the phone. Mr. Johnson was not criminally charged, but he was terminated from Sugar House Casino for violating the company's standard of conduct. Accordingly, the Office of Enforcement Counsel requested the Board revoke Mr. Johnson's non-gaming employee registration at this time.
Thank you. Questions or comments from the Board? May I have a motion?
Mr. Chairman, I move that the Board approve the revocation of Benson Johnson's non-gaming employee registration as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? Motion is adopted.
Thank you.
Mike Rowland again with the Office of Enforcement Counsel, and this is a request to revoke the gaming employee permit of Barbara Hernandez. Ms. Hernandez held the position of cage cashier at Sands Casino. She was observed placing a $40 tip she received from a patron into her pants pocket, as opposed to placing these tips in a tote container. She ultimately admitted to taking the $40 tip both verbally and in writing. Ms. Hernandez was terminated by Sands but not criminally charged, and the matter is now before the Board to consider the revocation of the gaming employee permit of Barbara Hernandez.
Questions or comments from the Board? May I have a motion?
Mr. Chairman, I move that the Board approve the revocation of Barbara Hernandez gaming employee occupation permit as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? Motion's adopted.
The remaining 7 matters on the agenda consist of enforcement actions in which the Office of Enforcement Counsel has filed petitions seeking the involuntary exclusion of individuals whose presence in a licensed facility are inimical to the interests of the Commonwealth and are licensed gaming therein. In each instance, the petition for exclusion has been filed with the Board's Office of Hearings and Appeal and properly served upon the individual named in each petition. The individual named in the petition failed to respond within 30 days as required by Board regulation. As a result, the Office of Enforcement Counsel filed a request for default judgment and properly served the same upon each individual. Thereby, all facts in each petition are deemed admitted. All filed documents have been provided to the Board, and the matter is presently ripe for the Board's consideration. Once again, we'll read a brief summation of the facts. It should be noted that if the Board orders the proposed exclusions, each individual's photo, personal identifiers, and a summary of the inimical conduct will be placed on the Board's public website.
Thank you.
Morning, Dustin Miller, once again on behalf of the Office of Enforcement Counsel. The next matter today is a request for placement on the Board's excluded persons list involving Maurice Howard. The Office of Enforcement Counsel filed a petition to place Mr. Howard on the exclusion list on July 11, 2016, for removing a losing wager from a blackjack table before the dealer could collect it, threatening Parks Casino employees, and leaving Parks Casino without making restitution on February 11, 2016. Mr. Howard was charged with 2 counts of terroristic threats, 2 counts of theft, and a count of disorderly conduct due to the incident. This time, based upon the foregoing, the Office of Enforcement Counsel asked that the Board place Maurice Howard on the Board's excluded persons list.
Questions or comments from the Board? May I have a motion?
Mr. Chairman, I move that the Board approve the addition of Maurice Howard to the PGCB involuntary exclusion list as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
Good morning again, John Crow, CROHA for the Office of Enforcement Counsel. The next matter for the Board's consideration is a petition to place Ryan Transu on the Board's excluded persons list for illegally past posting a bonus wager while gaming at Meadows Casino. Mr. Transu was charged with knowingly by trick or fraud, winning or reducing a loss, and ultimately pled guilty to disorderly conduct. The Office of Enforcement Counsel now requests that the Board place Ryan Transu on the Board's excluded persons list, which includes Mr. Transu's Mr. Transu's picture, physical description, and the summary of his inimical activity being placed on the board's public website.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the addition of Ryan Transu to the Pennsylvania Game and Control Board involuntary exclusion list as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
Thank you. Glenn Stewart again for the Office of Enforcement Counsel. Next for the board's consideration is the placement of Mustafa Whitfield on the exclusion list. In early November of 2015, Mr. Whitfield forcibly robbed 2 patrons in the parking garage of Harrah's Philadelphia Casino and Racetrack. As such, the Office of Enforcement Counsel requests the board place Mustafa Whitfield on the exclusion list.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move the board approve the addition of Mustafa Whitfield to the PGCB involuntary exclusion list as described by the Office of Enforcement Counsel.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
The next petition regards Tejas and Mary going on the board's involuntary exclusion list. In July 2016, Tejas and Mary attempted to use a fake ID to gain access to the gaming floor at Mount Airy Casino. He was subsequently cited by the Pennsylvania State Police and pled guilty. At this time, the Office of Enforcement Counsel requests that the board add Tejas as Mary to the board's involuntary exclusion list, and that his biographical information, a summary of his inimical behavior, and his photograph be placed on the board's public website.
Thank you. Questions from the board? May I have a motion?
Mr. Chairman, I move that the board approve the addition of Tejas Ameri to the PGCB involuntary exclusion list as described by the Office of Enforcement Counsel. I further move that Mr. Ameri may petition for removal from that list anytime after his 22nd birthday.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
The next petition is in regards to the placement of Maria Neira Pajares on the board's involuntary exclusion list. In July 2016, Maria Neira Pajares attempted to use a fake ID to gain access to the gaming floor at Mount Airy Casino. She was subsequently charged by the Pennsylvania State Police and pled guilty. And at this point in time, the Office of Enforcement Counsel requests that the board add Maria Neira Pajares to the board's involuntary exclusion list, and that a summary of her inimical behavior, her biographical information, and her photograph be placed on the board's public website.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the addition of Maria Pajares to the PGCB involuntary exclusion list as described by the Office of Enforcement Counsel. I further move that Ms. Pajares may petition for removal from the list any time after her 22nd birthday.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
The next petition is in regards to the placement of Matthew Roca on the board's involuntary exclusion list. In July 2016, Mr. Roca attempted to use a fake ID to gain access to the gaming floor at Mount Airy Casino. Mr. Roca was cited by the Pennsylvania State Police and subsequently also pled guilty. And at this time, the Office of Enforcement Counsel requests that the board place Matthew Roca on the board's involuntary exclusion list, and that his biographical information, a summary of his inimical behavior, and his photograph be placed on the board's public website.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the addition of Matthew Rocco to the PGCB involuntary exclusion list as described by the Office of Enforcement Counsel. I further move that Mr. Rocco may petition for removal from that list anytime after his 22nd birthday.
Second.
All in favor?
Aye.
All opposed? The motion's adopted.
OEC's final petition is in regards to the placement of Rebecca Yadouche on the board's involuntary exclusion list. In July 2016, Rebecca Yadouche attempted to use a fake ID to gain access to the gaming floor at Mount Airy Casino. Ms. Yadouche was subsequently cited by the Pennsylvania State Police and pled guilty. And at this time, the Office of Enforcement Counsel requests that the board add Rebecca Yadouche to the board's involuntary exclusion list, and that a summary of her inimical behavior, her biographical information, and her photograph be placed on the board's public website.
Questions or comments from the board? May I have a motion?
Mr. Chairman, I move that the board approve the addition of Rebecca Yadouche to the PGCB involuntary exclusion list as described by the Office of Enforcement Counsel. I further move that Ms. Yadouche may petition for removal from that list anytime after 1 year.
Second.
All in favor?
Aye.
All opposed? Motion's adopted. That concludes Office of Enforcement Counsel's report.
Thank you.
Okay, that concludes our business for today. Our next scheduled public session will be held on Wednesday, December 14th in this hearing room, and will begin at 10 o'clock in the morning. Are there any other final comments from the board or ex officio members? I have a motion to adjourn. Oh,
So
I'm
moved.
sorry, a comment?
Just shaking my head.
A motion to adjourn.
So moved.
All in favor? Aye. All opposed? Motion's adopted. Thank you all.